recording in process ಅಂತ so not now when we intro. Sir, good evening. Namaste, sir. This
Hello.
is Asma. I am the faculty coordinator of JSS Law College.
Hello, ma'am.
Hello, sir. Sir, with your permission, can we start, sir?
Yes, please.
Thank you, sir. Since Kalpesh, sir, will join us shortly, he is busy in some work. So, without further ado, I request Deepti to take over and give a brief introduction about Akash Gupta, sir. Over to you, Deepti.
Good evening, everyone. I'm Deepti PD, a final year student at JSS Law College, Mysuru, and I deem it an honor to welcome you all to the third session of the 10-day online capacity building program on ADR, legal aid, and allied laws, jointly organized by Pro Bono India and JSS Law College, Mysuru. It gives me an immense pleasure to introduce our distinguished speaker for the day, Professor Akash Gupta. Professor Akash Gupta is an associate professor and assistant director of the Center for ADR at Jindal Global Law School and visiting faculty at NLSIU Bengaluru, where he teaches arbitration. He has been appointed to the Young IAMSC Steering Committee 2025-2027 by the IAMC Hyderabad in recognition of his contributions to the field. And of CNNLU, Trichy, and Stockholm University, LLM in International Commercial Arbitration Law. Sir has also attended the Paris Arbitration Academy and Hague Academy on full scholarship and full sponsorship, respectively. Sir was awarded the Young ADR Academic of the Year in 2023 by the Asia Pacific Center for Arbitration and Mediation. He is a prolific author with 10 Scopus indexed publications across arbitration, mediation, and consumer ADR, published by Sage, Springer, Routledge, and Thomson Reuters. Sir regularly judges moot court and ADR competitions, including WIS, JESA, and FDI, and has conducted workshops at 50 plus law schools and holds several editorial and advisory roles with leading journals. With that, now I warmly invite Sir to begin today's session and share his valuable insights with us.
Over to you, sir. You can please start.
Thank you very much. Are you able to see my screen?
Fundamentals of arbitration law in India.
Yes, perfect. Okay, so first of all, I'd like to thank Professor Kalpesh, JSS Law School team, faculty, and the organizing committee for giving me this opportunity to talk about arbitration laws in India. So in the next 1 hour or so, I'm going to discuss some of the fundamentals of arbitration law in India. It's a very tough task to actually discuss some of the issues on arbitration within an hour, but I'll try my best to make sure that we touch upon the most important ones. So in the next 1 hour, this is the roadmap which I'm going to follow. The first is the legal framework. Then we'll talk about the arbitration agreement and the applicable laws in arbitration. And the later part of the discussion will be focusing on the challenge to an arbitral award and enforcement of an arbitral award, because that is the most important chunk of cases that we see within the Indian arbitration regime. Now, to start with the background of the legal framework of arbitration in India, we have to look at that what is the law for arbitration in India. So if we trace down the history, so let's start somewhere around 19th century, 1899, the first direct law on arbitration came. It was named as Indian Arbitration Act 1899, which was limited to the presidency towns. 1908 CPC came in. Now 1908 CPC was a code of civil procedure which was regulating civil litigation, not per se arbitration, but it was a great step which was applicable throughout the territory of India. 1940 was actually the first arbitration law which was applicable for the whole of the territory. The British ruled Indian territory. So 1940 was largely based on the English Arbitration Act, which was also applicable within the Indian jurisdiction. But 1940 Arbitration Act only provided for domestic arbitration. There was no discussion on the foreign arbitrations, which is actually a thing under 1996 Act. So 1996 Act was actually the first Indian Arbitration and Conciliation Act, which provided for the domestic arbitration, for foreign arbitration. All of this was discussed. But before 1996, 1940 Act was actually applicable. Once we got 1996 Act, and even so far, we have seen a lot of amendments to the 1996 Act, but the current law on arbitration and conciliation is actually 1996 Act, of course, read with the amendments. Now, 2001, we have seen, based on the UNCITRAL model law, the 1996 Act failed to adapt many aspects, so following which the Law Commission report took a comprehensive review of the Act, which was 2001. Then after that, from 2014, we have seen the 246 Law Commission. Based on the 246 Law Commission, we have seen so many amendments which have been done in the past 10-15 years. The last update for this is November 2024, when the draft arbitration bill was released. It's not floated in the parliament as of now, but it's a draft bill. So as we talk now, the current law for arbitration is Arbitration and Conciliation Act 1996. Now, if we look at the larger framework of how we resolve disputes, so there are different methods of resolving dispute. One is the traditional method of dispute resolution, that is litigation. The other one is what we call alternative dispute resolution. In the ADR, you have mediation, arbitration, and the other ones. But mediation and arbitration are one of the most preferred ones. And of course, arbitration is more preferred because in all the cases of arbitration, you will have the outcome, because the arbitrator will decide that whether A is wrong or whether B is wrong, how much has to be paid, who has to pay to whom. So this is the reason why 90% of the commercial companies in India sign up for an arbitration clause. Now, how you do an arbitration? You can actually divide it into two parts. One is the ad hoc arbitration, the other is the institutional arbitration. So ad hoc arbitration is where the parties A and B decide to appoint C as an arbitrator. They don't want to go to an institution to help it. And you don't have an arbitration rules, which is going to be applicable. You don't have an institution where you have a case manager helping you with all the different steps. So basically, in an ad hoc system, there is no institution involved, and the parties are responsible for deciding all the aspects of arbitration. For example, number of arbitrators, how the procedure for appointment will be, which laws are applicable, because there is no set rules for this, and the parties can actually draft their own rules. However, if you look at the institutional arbitration, first thing is that you have to pay an institutional fee, an administrative fee to the institution. So it's a bit expensive. And then you have an arbitration rules which will be applicable. So let's say if party A and party B are not able to nominate the sole arbitrator, they are not able to find one common name, then in that case, the institution will appoint the arbitrator. For every different step, there is a set rules, which is the institutional arbitration rules, which will be applicable for both the parties. So ad hoc versus institutional arbitration, just to give you an Indian perspective to this, Khetan and Co has recently done a survey where it was almost 55% of the Indian respondents said that we'll still prefer ad hoc arbitration, and 45% or near about 45% they said that we'll choose institutional. So as we talk now, according to this Khetan survey, majority is actually inclined towards ad hoc arbitration. However, if you look at all the developed arbitral jurisdictions, for example, France, for example, Singapore, you will see that majority of the cases go for institutional arbitration and not ad hoc arbitration. So it's a very different setting here in India, that we have more number of ad hoc arbitration. Then there are Indian parties who wants to still choose ad hoc arbitration. But if you look at the certainty, uniformity, more rules, and less court interventions, you'll see institutional arbitration is the way forward. So there exists a debate currently that is institutional arbitration versus ad hoc arbitration. Any questions so far?
Participants can kindly raise any queries that you have. You don't need to hesitate.
Okay, so I don't see a question. So let's go to the next part, that is stages of an arbitration proceeding. So how does an arbitration initiates? So first is notice for invoking arbitration. So party A, the claimant, sends a notice for invoking arbitration, and then the other party replies. After this notice of arbitration and the reply is done, then the parties select the arbitrators, they appoint the arbitrators. Then there are certain basic rules which has to be followed under the Indian Arbitration Act, which is equal treatment of parties, and the parties' chosen rules should be applicable. Seat of arbitration has to be provided, language of the arbitration has to be provided. Then it also provides from section 21 to 24 what is commencement of arbitration proceedings and hearing and written proceedings in India. Then section 9 is a provision which provides for interim measures by the court. Section 17 provides for interim measure by the arbitral tribunal. Then section 23 and 24 provides for oral hearings, written proceedings, statement of claim and defense. Section 31, 32 provides for how do you actually make an arbitral award, what are the requirements to have an arbitral award, whether it needs to have signed, whether it needs to have majority of the arbitrators who has to sign, when an arbitration is deemed to be terminated, all of this. Here comes the important part, that is section 34. Now, a lot of times you must have seen in the news, or if you read arbitration law, that an arbitral award was challenged, an arbitrator was biased, or an arbitrator acted beyond the scope of the arbitration agreement. Now, all of this relates to recourse against arbitral award. This is what we call challenging the award. Then section 35, 36 provides for finality and enforcement of arbitral awards. And then appeals under section 37. And these appeals are basically anything which has been decided by a court of law with respect to the arbitration, and then you take it to the higher courts, that is the appeals. Okay, any questions so far? Anyone? Okay, now let's look at the background of the Arbitration and Conciliation Act 1996. Where do we get this whole idea of this Arbitration Act 1996? So, in between 1940 and 1996, one of the big event was 1985 Ancestral Model Law on International Commercial Arbitration. Now, 1985, this model law is more like a template, which was created by UNCITRAL, United Nations Commission on International Trade Law, which any member country can adopt within their domestic setup. So India actually adopted UNCITRAL model law on arbitration, and the 1996 Act is actually a result of that. So our 1996 Act is not something which is, all drafted by the Indian Parliament or something. We have adopted UNCITRAL model law, and UNCITRAL model law is very international. A lot of countries have actually adopted UNCITRAL model law, including Singapore, including Hong Kong, and of course Malaysia, and India has actually adopted this in 1996. Now, when India adopted this, India also included the New York Convention 1958. Now, what is this New York Convention 1958? To understand this, we need to first understand what do we mean by domestic arbitration and what do we mean by foreign arbitration. When we say domestic arbitration, it means that the seat of the arbitration is in India. Now, you must be thinking, what is seat? I'll give you an example. Let's say A is the claimant, B is the respondent. If A and B enters into a contract which provides section 13 as the arbitration clause, any dispute arising out of this clause, any dispute arising out of the sales agreement shall be resolved through arbitration. Now, if you have to resolve this, you have to anchor the arbitration somewhere. That, let's say, if you have to go for challenging the arbitral award, that the arbitral award is against public policy, the arbitrator was biased, the arbitration agreement is invalid, you have to go to a court. Now, which courts? You have to choose a seat for that. So if you say that the seat is Singapore, it means that the challenge power rests with the Singaporean courts. If you say that the seat is Mysuru, the Mysuru courts will get the jurisdiction to hear the challenge. If you say that the seat is Sonipat, the Sonipat courts will get the jurisdiction to hear the challenge. Now, this is what we mean by seat. So wherever the seat is, the arbitration is anchored to that particular national arbitration law from that country. Now, if the seat is within the territory of India, that is a domestic arbitration. If the seat is beyond the territory of India, let's say Singapore, Malaysia, Paris, these are foreign arbitration. Now, why is that differentiation necessary? Because the Arbitration and Conciliation Act 1996 is divided into different parts. The part 1 provides for domestic arbitration, which means if the seat is in India, part 1 applies. Part 2 applies when the seat is outside India, which means foreign arbitration. Now, the larger problem comes when you have a foreign award which has to be enforced in India. Because let's say if the seat is in Mysuru, the applicable law for that is Arbitration and Conciliation Act. So enforcement is not an issue. But what if you choose a seat in Singapore? Whether India will enforce it? Now, this was the discussion before 1958. Finally, in 1958, the New York Convention came into picture, which provides that every member country of New York Convention has an obligation to enforce the foreign awards. Now, India is a signatory to it. India has also adopted this within the Arbitration and Conciliation Act. However, India has signed up to a reciprocal reservation, which means two set of reservation India has actually signed up to. One reservation is that India will only enforce awards coming from a member country of NYC. Second, only if it is a notified country within the Indian Gazette, only then India will enforce it. Now, this is an option given under Article 1 of the New York Convention, which India has exercised. So India has this reservation. So please don't think that India has an obligation to enforce arbitral awards coming from all the 170 plus countries. India signed up to a reservation of reciprocity, which is also extended towards only the countries which are notified by the government of India as a reciprocal country. And I think the number is almost around 45 or something. So this is New York Convention. Now, New York Convention 1958 and the Uncitrall Model Law 1985, both of them have been adopted and being inserted. And the result of that, the new law, which is the 1996 law, is called Arbitration and Conciliation Act 1996. Any questions so far on this? Anyone? Okay, let's go to the next one. Now, this whole arbitration law is dependent on the arbitration agreement. What do we mean by arbitration agreement? Let's say if A and B has a dispute, how do you resolve it? You can go to the courts. Do you need to have an agreement for that? The answer is no. But to go for an arbitration, you need to have an arbitration agreement in place. If you do not have an arbitration agreement, what is the dispute resolution mechanism? You have to go to courts. So unless until you have a consent to arbitrate, there cannot be any sort of arbitration. So if A and B are two commercial parties and they want to do an arbitration, in case if there exists any dispute, they have to sign up to an arbitration agreement, or you can also call it arbitration clause. Now, what are the elements of an arbitration agreement? Section 7 of the Arbitration Act actually provides this, that it needs to have a defined legal relationship. intention to arbitrate. It can be a written agreement, or through any sort of record, you can showcase that there exists an intention to arbitrate. And of course, you have to also showcase that the decision of the tribunal shall be final and binding, which means it shouldn't be like an arbitration clause cannot be like arbitration or litigation. It has to be certain that this is the only method of dispute resolution. So the larger test with respect to what constitutes an arbitration agreement is that the parties should have an unequivocal intention to arbitrate their disputes, which will resolve their disputes finally. This is what we call arbitration agreement. And the whole power of doing an arbitration, the powers of the arbitral tribunal, or the power of arbitration, or the norm for arbitration, is actually the arbitration agreement, because this is the place where the power comes for doing an arbitration. Because unless until you have a consent to arbitrate, how will you arbitrate? So when you have an arbitration agreement, it has a negative obligation, it has a positive obligation. Positive obligation is that you have to undergo arbitration. Negative obligation is that you cannot move to the courts to resolve your disputes. This is the understanding of Section 7 Arbitration Agreement. Now, in one of the case, Centro Trade versus Hindustan Copper Limited, there are 3 Centro Trade cases. So the third Centro Trade, which was decided by the Supreme Court, the whole issue was that whether you can choose to have first arbitration, a primary arbitration, and then an appellate arbitration. So the answer in this case was this, that if the parties want to have an appellate arbitration in place, the parties are free to do that. Why? Because it's party autonomy, which is an essential principle of arbitration, because the parties can decide how they want to do arbitration. If the parties say that one arbitration and that is final, very good. If they say that first arbitration, the losing party can initiate another arbitration within 30 days and the second arbitration will be final, that is also fine, and that is called appellate arbitration. So the whole question was whether appellate arbitration is allowed and that constitutes a valid arbitration agreement. The court said yes, because it's party autonomy and it's a party driven process. For example, whether you can choose a judge in a court of law. Can you choose which law should be applicable in a court of law? The answer is no. But when you move towards arbitration, you can choose your arbitrator, you can choose the applicable law. So the parties gets to choose all of this. That's why we call that it's a party tailored dispute resolution mechanism. Okay. Any questions so far?
There's a question from the boardroom, if you permit.
Yes, please.
Sir, how many layers of appeal in an arbitration can be allowed in a clause? If we draft a clause, like you said in the previous case, that an appellate arbitration can be held, how many layers of it can be allowed? Because then it will become a never-ending.
Okay. Now, think of this. Let's say that you are a CEO of a company, and I'm also a CEO of a company, and when we negotiate the sales agreement, maybe in some cases we'll have an appellate arbitration in place, but do you actually think it's practical? When I say practical, it means cost. Because one arbitration is itself going to cost us a lot. It's not a court that we don't have to pay the fees for the judges. It's an arbitration. We have to bear the cost of the arbitrators. So let's say if we keep 2 arbitrations, one arbitration and then another arbitration, we have to also take care of the expenses. So practically, it's not going to be something which we want to keep it unless until it's a multi-billion dispute with respect to oil and gas, or it's a very big construction dispute. So it's not very often that you want to have more than one arbitration because it also has a cost associated to it. But answering your question, how many appellate arbitrations you can keep depends on party autonomy. If you want to keep 3 arbitrations, but think of this, when you are actually representing a company, will you be ready to do this? Because then you have to also bear the cost. Who bears the cost for arbitration? The parties. So practically, it's not a very commercially sound thing to do. Do you get it? But if your question is, can we have an appellate arbitration? The answer is yes. There is no problem.
Thank you, sir.
Yeah. Okay, I see a question. Under what circumstances parties can prefer an arbitration award? I think your question is when you should prefer an arbitration than litigation. So, commercial parties, a lot of times they want to resolve their disputes in a quick manner and they don't want the public to know about the dispute. I'll give you an example. Let's say it's A and B, two companies which are both listed companies, they have a dispute. They don't want to go to public and wash their dirty clothes in the public, right? So what they want to do is they want to resolve this confidentially. So this is a classic case where you will use arbitration because nobody can go to public and talk about it. So this is one of the primary reasons why parties want to go for arbitration instead of litigation. The second is, of course, that it's a bit, not it's a bit, it's much more faster than litigation, isn't it? So, and you can also choose an expert from the domain of the subject matter to be appointed as an arbitrator. So these are the reasons why commercial parties choose arbitration rather than going to courts. Any other question before we go to the next part? Okay, so now let's discuss the applicable laws in international arbitration. So if we look at the slide, the first one is substantive law. Let's say A versus B, there are three issues. The first issue is whether the arbitration agreement is valid. Second is whether B has breached the contract. Third is whether B should pay rupees 10 lakhs to A. Now, which law applies to the validity of the arbitration agreement? The first issue. Which law applies to decide whether there is a breach of contract? Now let's discuss this. First one is proper law of contract, which is also called substantive law or lex contractus. So if you have to decide the rights and obligations of the parties, that whether there was a breach of contract, who has to pay to whom, then you have to look into the merits, which is the substantive law of the contract. So that's first one. Now, if you have to look at the arbitration agreement validity, you have to look at the law governing arbitration agreement. Okay. Then the third law is called the seat law. If you have to look at which court gets the jurisdiction to hear the challenge, that's the seat law or the national arbitration law of the seat, which you have to look at. Let's say you want to challenge that party A was not under capacity to enter into this contract. Now, which law applies to this? A, if it's a person, then you have to look into the rule of majority, the contract law. Or if A is a company, you have to look into the domicile. Let's say if A comes from Singapore, whether under Singaporean company law, whether that company, according to that law, whether it was under the capacity to arbitrate contract or not. The last one is the place of enforcement. Let's say if A versus B, enforcement has to take place in Malaysia. Which law will apply to the enforcement petition? The Malaysian laws will be applicable in terms of an enforcement. Let's say if you have to enforce an award which is coming from Malaysia and you have to enforce it in Mysuru, you have to enforce in Mysuru using the Indian laws on enforcement, which will be the Indian Arbitration and Conciliation Act. Okay, so these are the different set of applicable laws in international arbitration. Sometimes you'll also see that the seat law and the law governing arbitration agreement can be same, it can be different. But please understand that the seat law is different than the law governing arbitration agreement. So anything with respect to the arbitration agreement, validity, powers of the arbitral tribunal, scope of arbitration agreement has to be discussed with respect to law governing arbitration agreement. Anything with respect to challenge, appointment, all of this, it has to be discussed in line with the national arbitration law or the seat law. Okay. Any questions on the applicable laws? Okay, now let's go to the last two important part of the discussion, that is section 34 and section 48 of the award. Now, what is section 34? Section 34 provides for setting aside of the award. Okay, I see a question on the chat box. How does the location where an arbitration agreement is enforced affect the enforcement and recognition of an arbitration award? Can you please unmute and ask this question? I'm not sure if I understand your question. If your question is, okay,
Sir, I'll just enable her
yeah,
1 minute. Just give me a second.
yeah, they're just making sure that you get a chance to speak. Yeah.
Sir, I think she's unable to access the microphone. I think it's a technical issue.
Okay, so technically the enforcement of an arbitration award has nothing to do with the arbitration agreement enforcement. So let's say if you have an award against a party B and B has assets in 50 countries, you can choose any of those countries wherever you want to go and enforce it. And usually you choose the place where it is a pro-enforcement regime to enforce the arbitration award. So first thing you look at it is whether New York Convention is something which is a part of their domestic law. Second, you'll see how the judiciary reacts to the enforcement petitions, whether they entertain, whether they go for a pro-enforcement regime or whether they just say no because it's a company from their own jurisdiction. So this is what you have to look at. But New York Convention helps you greatly with respect to enforcing foreign arbitral awards. Okay, now if you look at the section 34 of the Indian Arbitration Act, this provides for recourse against arbitral award. Now, once the arbitral award is rendered, you cannot go to the court and say that the arbitrators have decided in a way which is not favoring me, which is favoring party B. So let's say there are two interpretations. One is favoring A, the other one is favoring B. Can you go to the court and challenge it based on this, that it's not in favor of you? The answer is no. You can only challenge the award based on certain grounds which are provided under section 34. And this is a challenge procedure. This is a challenge. This is not an appeal. So majority of these grounds, so majority of the cases, you'll see this in common, that unless until one of the ground is triggered from section 34, there is no way that the courts will accept your challenge. So let's look at the grounds. The first one is the party is under some incapacity. Let's say the party was not even capable enough to enter into the arbitration agreement. Second is the validity of the arbitration agreement. Third is they didn't get the proper opportunity of being heard. Fourth is excess of mandate, which means that let's say there were two issues which has to be decided, and or the arbitration agreement provided to discuss disputes arising out of contract A, while the award actually discusses contract B. Then it becomes an excess of mandate. The award will be annulled. Fifth is the composition of the arbitral tribunal, or the procedure which was agreed by the parties is not followed. So these are five. Apart from this, the B part is if the court finds that the subject matter is non-suitable for arbitration. Let's say husband and wife dispute, or let's say it's a sexual harassment dispute. So these are the subject matters which are non-suitable for arbitration. Second is the arbitral award is in conflict with the public policy of India. So what is public policy of India? This is explained in explanation 1. The first one is the making of the award was induced or affected by fraud or corruption. Second, it is in contravention with the fundamental policy of Indian law. Third, it is in conflict with the most basic notions of morality or justice. For the avoidance of doubt, the test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. Now, what does this mean? In the name of looking at the fundamental policy of Indian law, you cannot do a review on the merits of the dispute. Okay, you can only look at the procedural parts of the award. 2A provides that an arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside by the court if the court finds that the award is vitiated by patent illegality on the face of the award. Now, patent illegality is a new ground which is added. That is the reason why we have this 2A, which is a new addition based on the ground of patent illegality. Now, what do we mean by patent illegality? An award which is so bizarre that it is not even a possible interpretation to reach. In that case, you can use patent illegality as a ground. But patent illegality, you can only use it when it's a non-ICA. What is non-ICA? Non-international commercial arbitration, which means if A and B are both Indian parties, then you can use patent illegality. But let's say it's Sangyong, which is a South Korean party versus NHAI. In that case, you cannot use patent illegality because Sangyong is a South Korean party. So this is section 34. Now, every arbitral award which is rendered in India, the Indian courts can hear section 34 challenge. However, the party which has lost arbitration is called award debtor. The award debtor can apply section 34 to the court. However, one of the grounds which we just discussed has to be triggered. If none of the grounds are triggered from this, a court cannot interfere with the arbitration award. Okay. And the timelines which is provided as an application for setting aside may not be made after 3 months have elapsed from the date on which the party making that application had received the arbitral award. If a request had been made under section 33, which is more like an error is there and then you refer it back to the arbitral tribunal, from the date on which that request had been disposed of by the arbitral tribunal, provided that if the court is satisfied that the applicant was prevented by sufficient cause. But that cannot go beyond the 30 days from 3 months. So the timeline is 3 months plus 30 days. Any questions so far?
So there's a question in the chat box.
Okay.
Can I read it out to you?
Yes, please.
What if a cause of action occurs on international waters and arbitration agreement is silent about the jurisdiction which law will apply?
Please understand this. When we talk about arbitration are of different kinds. I'll give you an example. Do you think that India and Pakistan can resolve a border dispute with arbitration? Anyone?
Yes,
You
sir,
need to
maybe.
write on the chat box. India and Pakistan, do you think, is there any possibility that India and Pakistan can resolve a border dispute with arbitration?
Yes, sir.
No, sir.
What if I tell you that India and Pakistan had a very famous arbitration through which they settled their boundary dispute in the Kutch area of Gujarat? And this is called Run of Kutch arbitration in between India and Pakistan, and the arbitration took place under the aegis of Permanent Court of Arbitration in Hague from the Peace Palace. So it actually happened. Now, those arbitrations are very different than these commercial arbitrations. How come? In those arbitrations, the two states have to give consent for arbitration. Unless until you have given a consent, you can't do a state-to-state arbitration. I'll give you another example. In this water treaty actually provides that India and Pakistan have given consent for arbitration. That's how you have Indus Water Treaty arbitration. Now, when you ask me about the international waters and ITLOS, that's a different sphere of arbitration. If the member countries have signed up to that and have consented that any dispute arising out of these law of the sea, and if India is a member, then of course the dispute resolution mechanism will take place. But that's very different. That's called an ITLOS arbitration. That's different than a commercial arbitration. So either you are a part of a bilateral, multilateral treaty, or it's just two states coming together and consent to it. Unless until you have the consent, you can't have an arbitration. So you can't force another person to have an arbitration. You need to first have an arbitration agreement. So when you say that international waters, you have to look into the applicable law. So if let's say there is a treaty in between 5 countries and an international water dispute arises from that treaty, and that treaty provides for arbitration, then arbitration will take place. If that treaty does not provide for arbitration, what is the ultimate dispute resolution mechanism? If all of them are a party to United Nations, then you have to go to ICJ. So it's not that easy that you can force the other side to go for arbitration. So everything is dependent on a regime. Either you are a party to United Nations, then ICJ will be applicable. If you are a party to Rome Statute, then International Criminal Court will be applicable. If you are a party to ITLOS, then ITLOS dispute resolution mechanism will be applicable. But when we are talking about this arbitration, we are talking about commercial arbitration. We are not discussing state arbitration or investment arbitration. Okay. Now, the other question is, what are some best practices in drafting arbitration agreements? So I'll highly recommend Gary Bond's book on drafting arbitration agreement, where he discusses a lot of different issues. For example, the more detailed arbitration agreements are, the better it is. For example, if you're choosing an arbitration rules, even if you don't have a very detailed clause, everything is all fine because the arbitration rules provide all the details. For example, how much time for notice of arbitration, what you have to do next, how will you appoint arbitrator, how many days the scrutiny of award will take place, if there is a challenge to arbitrator, what will happen. But if it's an ad hoc arbitration, you don't provide all these details. I'll give you an example. The number of arbitrators, procedure of arbitrators appointment, procedure for challenge to arbitrators, whether a scrutiny of award will be there or not, who will take care of the costs with respect to expert witnesses, who will take care of the bookings. So you have to make sure that it's very detailed. Language, which language do you actually decide for? What if in the arbitration clause you don't provide seat? So you have to provide the seat, you have to provide the number of arbitrators, language. Then you have to also provide the venue for arbitration, how the arbitration proceedings will take place. For example, in Mumbai or in Bangalore, where you guys will meet physically or do this. So all of these details have to be there. Unless until, or otherwise, it's very simple that you choose an institutional rules, which actually provides for all of these. And this is the reason why people pay certain money to the institutions as an administrative fee, that even if we pay some amount, still you get all the services of the support for the arbitration. Okay. Now let's look at this case, NHAI versus Hakim. This is a Supreme Court judgment where the court has to look into Section 34 application. And the court said that unless until Section 34, any of the grounds are triggered, we are not going to interfere with the arbitral award. And in this case, they used the term Lakshman Rekha, and they said Section 34 is more like a Lakshman Rekha in between the arbitral award and the challenge. Unless until there is anything triggered, we are not going to interfere with the award. It's final and binding. So this was a very pro-arbitration judgment, which provided that arbitration awards are going to be not interfered with unless until one of the ground is triggered, which we just discussed. Now, in another case, 2019, in Sangyong case, what happened? The Supreme Court of India used Article 142 of the Constitution. The 142 of the Constitution provides that the Supreme Court has a power to do complete justice. And so the award was pretty much like A has to pay to B. At the end of this proceedings in Sangyong, they said B has to pay to A, and they upheld the minority award. So there were 3 arbitrators, 2 decided in favor of A, 1 decided in favor of B. The Supreme Court said that we are going to use this exceptional power of Article 142 and we are going to uphold the minority decision of the award between the parties. They said that usually Section 34 do not provide the power of modification, but in this case, we are going to do this because if we say that this award is challenged successfully, this award is annulled, you have to go back and start afresh another arbitration. So we are going to save a lot of time and we are going to correct all of this error in one go. So we say that the minority decision is upheld. Any questions so far? Okay. Now, the last part of our discussion is we discuss the domestic awards, its setting aside procedure under Section 34. Let's go to part 2 of the Arbitration Act in India, that is Section 48. Now, Section 48 is actually an adoption of Article 5 of the New York Convention. Now, this provides that the Indian court has an obligation to recognize and enforce the awards unless until one of the following ground is triggered. Now, the grounds are pretty much similar to what is provided under Section 34. For example, the first one is the incapacity of the parties, the arbitration agreement validity. Second is the proper procedure is not followed. Third is that the award deals with excess of mandate. Fourth is the composition of the arbitral authority or the procedure was not in accordance with the parties' chosen procedure. Fifth is that if the award is challenged successfully at the seat, it can also be a ground to resist enforcement. So let's say if the seat is Singapore and the Singaporean courts say that the award is annulled, it's challenged successfully, that can be a ground in India to refuse enforcement. Then apart from these, there are two more grounds, which is the court can look into this on their own also. First one is that the arbitrability, whether the subject matter is not suitable for arbitration. Second is that the award is contrary to the public policy. Now, which law should we look at with respect to arbitrability? We have to look at the law governing arbitration agreement. And we don't have to look at the seat law or the enforcement law. We have to look at the law governing arbitration agreement. Now, let's look at one of the case, which is Cruise City versus Unitech. In this case, it was a London Court of International Arbitration case. The dispute arose in between the parties, and Cruise City sought enforcement of foreign arbitral award in India under the New York Convention, while Unitech opposed enforcement on various grounds. Now, Cruise City argued that the arbitral award was final and binding, issued by a competent tribunal under LCIA rules. The award met all the requirements under Section 44. Now, Section 44 provides the requirements that you have to file the arbitral award and you have to also file the arbitration agreement. And if it is in a different language than English, then you have to file the certified copies. Under Indian law, foreign award can only be refused enforcement on narrower grounds, which is provided under Section 48, which is almost like Article 5 of the New York Convention. Cruise City contended that Unitech's reliance on the public policy exception was an attempt to delay enforcement rather than a legitimate concern. Unitech has opposed the enforcement of the award essentially on three grounds. First, that the award includes a decision on matters beyond the scope of submission to arbitration. Second, it did not have the proper notice. Third, that the arbitral tribunal for responding to the claim for payment against the purchase of shares. Third is the enforcement of the award would be contrary to the public policy of India as it will violate FEMA provisions. However, the court held that this award is going to be enforceable because none of the grounds are triggered and there was no violation of FEMA. And the court said none of the grounds within Section 48 vis-a-vis Article 5 of the New York Convention is triggered. Unless until any of the ground is triggered, we are going to enforce the foreign arbitration award. And in this case, the court actually enforced the arbitration and the court refused the resistance from the respondent under Section 48. Now, if we look at the major arbitration institutions, so the hegemony for the arbitration institutions in the world is pretty much by these institutions. First is ICC, which is in Paris, London Court of International Arbitration, Singapore International Arbitration Center. If we look at ICC Paris, the recent report provides that the top 10 countries from where the disputes they get. So in the top 10, India is there. It's pretty much the same with Singapore International Arbitration Center. So majority of our disputes, majority of the companies from India, they choose ICC and Singapore International Arbitration Centers arbitration. So the Indian parties themselves don't want to arbitrate in India, but they choose a foreign seat, especially when you have an international contract with another company. The fourth one is American Arbitration Association, which also has an office in Singapore, but their headquarters in New York. Hong Kong International Arbitration Center. Then there is one CTAC in Beijing. And then the Indian ones, there are three leading ones: Mumbai Center for International Arbitration in Mumbai, International Arbitration and Mediation Center, Hyderabad, and one in New Delhi, which is India International Arbitration Center. Now, these institutions are actually not involved in the decision making, but they actually help you with everything relating to arbitration. So they have a list of arbitrators which anyone can access from their website. They have a list of fees and model fees, that how much you have to pay. So if you're so they have this range of the claim amount, and you can look at what will be the administrative fee that you have to pay to the institution, what will be the model arbitrator's fee according to your claim amount. All of this is on their website. Once you pay this, administrative fee, once you include an arbitration clause which reads something like this: any dispute arising out of this contract shall be resolved through arbitration, and the applicable rules is ICC rules. It means that ICC can only administer these disputes, which means you have to go to ICC because you are using ICC rules. So only they have the power to administer it. Once you write this, what you have to do is send a notification to this institution, and the institution takes care of all of the administrative part for conducting this arbitration, starting from appointment of arbitrators to emergency arbitration, scrutiny of award, finalization of award, sending the awards, everything. This is more like, they have this rules which provides for all of these different stages. And in India, the major ones are Mumbai, Hyderabad, and Delhi ones. So with this, I stop here, and I'm open to any questions which you have now. Okay, so Megha has a question that if confidentiality is breached, what is the remedy for that? So Section 42A of the Arbitration Act, it's an amended provision, 42A. It's a new provision which provides that every stakeholder of an arbitration is bound by confidentiality. However, it's a tiger without the hunting teeth, because there is no liability part attached to Section 42A. So if you ask me what will be the liability, there is no answer to that. But of course, it doesn't mean that the courts cannot make you liable if you breach confidentiality. So I'll say India has taken a step forward by providing confidentiality under Section 42A with respect to arbitration, but India could have taken another step by providing a civil liability of the arbitrators or parties, whoever is flouting confidentiality. I'll give you an example of the Spanish Arbitration Act. I think Section 21 of the Spanish Arbitration Act actually provides that confidentiality has to be followed, and it also provides a civil liability attached to it. But the Indian Act is silent on this. So if you have to get a remedy, you have to go to court and you have to file an application for that. But what will be the remedy for that depends, because the Act do not provide that what will be the liability in that case. Okay, so I have completed my presentation, and now I'm open to questions if you have any. Okay, so another question is, if both countries after entering into arbitration contract become enemy nations, then can third jurisdictions be involved? I'm not able to understand what you are saying. So you are saying it's a state to state arbitration. Two countries sign up to an arbitration clause, later they become enemy nations. What will happen after that?
Yes, sir.
The third jurisdiction, what the third jurisdiction will do? Nothing.
Sir, can jurisdiction of any other country can be involved?
No, understand this. Let's say country A and B decides to have an arbitration. Once you have appointed an arbitrator, it doesn't matter whether you are an enemy state, whether you are a friendly state, the arbitrator, whatever they render, is going to be final and binding upon you, because you were the one who gave the consent. Whether you follow the arbitral award or not, that's another issue, right? But if you have consented, you have the panel formed and the panel decides. It's going to be binding upon you guys because you were the one who gave the consent. So technically for enforcement, it's very difficult to get an enforcement in between enemy states. But how will the third jurisdiction can be involved into this? The answer is no. But of course, I understand that once you become an enemy state, the enforcement is an issue, of course. Okay, so another question is from Ananya, the Arbitration and Conciliation Act also deals with the Geneva Convention. Does India have a similar reciprocity like it does? Okay, please understand this. Geneva Convention is 1927, Geneva Protocol is 1923. Geneva Convention is only applicable anything before 1996 Act. Because in 1996 Act, we have New York Convention. Geneva Convention provided for a double executor with respect to enforcement of foreign arbitral award, which means that you have to get an approval of the seat courts, plus you have to go to the enforcement court, then it will get enforced. So Geneva Convention awards, now technically it's there in the Arbitration Act, but technically it's redundant. How many arbitration enforcements are taking place, which has an applicable law of 1940 Act? Technically, maybe 1, 2 or some more than that, but not really. So Geneva Convention is a part to it, but it will only apply to cases pre-1996. So Geneva Convention, technically it's a part, but it's redundant now because now we follow the New York Convention regime. So Geneva Convention is actually a predecessor of New York Convention. So India was a party to Geneva Convention, but now New York Convention has superseded all of this regime because Geneva Protocol 1923 provided for enforcement of arbitral agreements. Geneva Convention 1927 provided for arbitration award enforcement. Both of them were clubbed together under New York Convention 1958. Article 2 provides for arbitration agreement enforcement. Article 5 provides for arbitral award enforcement. So technically it's NYC, which is the applicable law. Unless until you go pre-1996. So let's say if there is an enforcement for which the applicable law is 1940 law, then you have to, of course, use Geneva Convention. NYC will not be applicable because NYC came only later. Any other questions?
Good evening, sir. I had a question with respect to venue of arbitration and seat of arbitration. The difference between them, and what if in the arbitration agreement they just mentioned the venue? So what will be the seat of the arbitration process?
Okay, now let's understand the difference. Seat, when I say seat is Sonipat, it means the national arbitration law of Sonipat will be the applicable law to the arbitration proceeding. So when I say Sonipat, Mysuru, what is the national arbitration law? The national arbitration law is Arbitration and Conciliation Act 1996. This is what we call seat theory according to Gary Bond. Now what is venue? When I say seat is Mysuru and venue is Sonipat, what I mean is this, that if you have to go for challenge, you have to go to Mysuru court. Why? Because the seat is Mysuru. So what do we mean by venue Sonipat? Venue means that when we have to convene the arbitration proceeding, when we have to meet, we'll have the arbitration proceedings here in Sonipat. So venue can be anywhere. Or let's say, I say that Goa is the best place to convene the arbitration proceedings. So we can choose Goa as a venue. But that has nothing to do with challenge procedure or anything. But seat is highly relevant because only the seat courts get the power to look into the challenge. Now coming to the second part of your question, if there is no mention of seat and if there is a mention of only venue, in some of the cases you can actually say that if venue is Mysuru, there is no mention of seat and there is nothing mentioned, venue can also be deemed as the seat. However, that's not always the case. I'll give you an example. If you provide that the applicable rules will be ICC rules, ICC Paris rules, and venue is Mysuru. ICC rules provide that if you do not provide the seat explicitly, the ICC court will decide the seat. And in majority of the cases, they say that by default, Paris is the seat. So the rules themselves say if you do not provide the seat explicitly, it's going to be their headquarters, which will be the seat. So not always the case that venue can be the seat. But of course, let's say if it's an ad hoc arbitration, you say that the seat is Mysuru, you don't mention seat, then there may be a chance that the courts will interpret or the arbitral tribunal will interpret that venue is equivalent to seat. But please understand that both are two different things. Seat is very much important for challenge and to understand which courts have the jurisdiction. Venue, it can be anywhere. For example, we are having a Zoom call. Can Zoom be a venue? The answer is yes. MS Teams can be a venue? The answer is yes. But can Zoom be a seat? The answer is no. Why? Because do we have a national arbitration law of Zoom? No. This is the thin line of difference. Okay. Any other question?
Good evening, sir. We have a question from Nainita 6th LLB JSS Law College. Her question is, when it comes to grant of interim measures under Section 9 and Section 17 of the Arbitration Act, which section has widened scope?
So here is the thing. If you want an interim measure, if the arbitral tribunal is already constituted, the rule is that you have to go to the arbitral tribunal under Section 17, unless until you think that the remedy is not going to be fruitful. So the first shot is given, rests with the arbitral tribunal. Only in a case where you think that the arbitral tribunal will not be able to provide you an appropriate remedy, you can use Section 9. But let's say if the arbitral tribunal is not constituted, in that case, you can go to Section 9, which is the court-ordered interim measure. Now, apart from Section 9 and Section 17, I'll tell you about Section 9A, which is there in the proposed draft bill on the Arbitration Act, which provides for emergency arbitration. Now, what is emergency arbitration? This is something which was started by American Arbitration Association and which was later also followed by Stockholm Chamber of Commerce. So let's say if the arbitral tribunal is not constituted, you can go to the courts, but the courts will take some sweet time to actually decide your interim measure. So there is something called emergency arbitration. In a span of 7 to 10 days, you appoint an emergency arbitrator to render that interim measure. And everything with respect to that will wrap up within 10 days. It's just that it's expensive, but you'll get an emergency arbitration award within 10 days. So that is a new thing which is, being followed in a lot of places, including India. For example, the Mumbai Center for International Arbitration has this. IMC rules also have it, and I'm pretty much sure that IIAC will also have this. Any other question?
Any other questions from the participants? You can even put your questions in the chat box. If there are no questions, I seek the permission of sir to close the session.
Please, ma'am.
Thank you so much, sir. Over to you, Deepika, for vote of thanks.
I'd like to extend my heartfelt gratitude to our esteemed resource person, Professor Akash Gupta, for sharing the invaluable insights and expertise on arbitration. Your presentation has significantly enriched our understanding on this aspect. I'd also like to thank all the participants for their active engagement and thoughtful questions. Your contribution have made a successful session. Thank you, one and all.
Thank you so much, sir. Thank you, all the enthusiastic participants.
Thank you very much, ma'am. Thank you.
Delightful questions. Thank you, sir. Can we close the session, sir?
Yes, please. And all the best for the rest of the course. Thank you very much.
Thank you so much, sir. Thank you, sir. Thank you.